right, welcome back. Back on the record. You can have a seat. Right. And we're ready for closing arguments.
Good afternoon, ladies and gentlemen. I want to thank you again for listening carefully. I want to thank you for all your questions and keeping an open mind. So as I stated earlier, we're here today because on October 2nd, for this man, Carlos Fisher, assaulted his wife, Fisher, by holding his fist, bringing his fist up as if he was going to punch her while he was standing next to her and extending his fist forward. And he also told Ms. Fisher that he was going to light her ass up. You heard testimony from Ms. Fisher that this happened at 6112 Swan Lake in Romulus, Michigan, in the county of Wayne. You heard testimony from Ms. Fisher and, you heard testimony from Stacey Fisher and Carlos Fisher that the parties were married at the time of the incident. You also heard testimony, you heard a lot of testimony from complaining witnesses, Stacey Fisher. You heard her testify that, as she stated, defendant was right next to her when he drew his fist back and acted like he was going to punch her. She testified that she believed that he was going to hit her or physically harm her when he pulled his fist back. And I am going to, the judge is going to give you a whole bunch of jury instructions. I'm not going to read them to you because the judge is going to read them to you. I do want to highlight one from the witness credibility jury instruction. And it states, you do not have to accept or reject everything the witness said. You are free to believe all, none, or part of someone's testimony. And when considering witness credibility, there are many factors, but all in all, what are the factors? All in all, how reasonable is the witness's testimony when you think about all the other evidence in the case? So in this case, Ms. Fisher, Ms. Stacey Fisher, when she originally called 911, she told the 911 operator that defendant had threatened to light her ass up, and she told police that he had reached for his pocket and that he had a gun. She testified that she did not tell 911 that the defendant had pulled his fist back like he was going to punch her because she was more focused on the gun. She was more focused on the more lethal threat in this case. She testified that she did not leave. She told the 911 operator why should she have to leave. We heard testimony from her that part of the reason she didn't leave is she had nowhere to go. And during one year, I know we talked about the various reasons that there can be not leave a situation right away, or why, we might stay in a situation why someone might stay in a situation that's dangerous. You heard testimony from Carlos Fisher, the part defendant and Stacey Fisher's daughter, who overheard defendant state that he was going to light Ms. Fisher's ass up. And you also saw Stacey.
Tension fills the room. One night, one argument, one accusation. Every word under the microscope. The jury must untangle fear from fact and decide where the truth really lies.
Fisher and Carlos Fisher you saw the written statements that were admitted as defense exhibit 1 and 2 in complaining witnesses, or in Stacey Fisher's written statement. She does again state that defendant threatened to light her ass up and reach towards his pocket like he had a gun and pulled his fist back. So beyond the reason, the judge is going to tell you more about what exactly the legal definition of reasonable doubt is, but that's why we have you guys here to decide this. In short, a reasonable doubt is a fair, honest doubt or an evidence or lack of evidence. It is not merely an imaginary or possible doubt. And the thing I want to emphasize is beyond a reasonable doubt does not mean beyond all doubt, or beyond all doubt. I don't have to prove where someone normally parks their car or who owned a certain car. I just have to prove that on October 22nd, 2024, at that location in Romulus, defendant pulled his fist back as if he was going to punch Ms. Fisher. I have to prove that Ms. Fisher reasonably believed that she was about to be punched. I have to prove that the defendant's action of pulling his fist back was was intentional. And I have to prove the parties were married at the time of the incident. I submit to you that when you go back there and you rely on your collective memories, when you take the evidence, when you view everything as a whole, I believe that you will return a fair just verdict. Thank you.
Mr. Hadley.
Thank you, ladies and gentlemen of the jury, for bearing with us today. I know it was a long day. I want to hark back to what we started out with. What did you hear? What didn't you? What actually passed the sentence? Now, we all know that if all it took was somebody to come in and make an accusation against somebody that they were angry with, any one of us, all of us, would be charged at any point in time. So we know it's not that. We know that you need more than that. And we know that law enforcement responded that night. We heard from these guys today. They couldn't remember everything. They did their job. They showed up and they gathered statements. And they gathered the available evidence that was there. Simply put, ladies and gentlemen, the jury, the only evidence that we have is a self-serving statement from an individual who had strong motive to lie. Now, I don't blame her for lying, and I'm not here to defend everything that came out of my client's mouth. As we've all said, we all say things, sometimes hurtful things, to those we love. This is a marriage, as you heard evidence today, that had been broken down. It was not going well. And unfortunately, I even had a biological child of these two individuals who kind of got pulled into this mix. You can use your judgment, ladies and gentlemen of the jury, when you saw how everyone testified today, of how credible or how invested they seem. I truly, again, felt for the party's daughter. I don't think that she came in here today and wanted to be involved. I think when police showed up that night, her very minimal bare-bones statements were pretty indicative of her reluctance to get involved. Ladies and gentlemen, you need to use your common sense when it comes to Carlos Fisher's testimony. If you listen to Mrs. Fisher, she'd have you believe that the only thing that her daughter did was all light your ass up. What we heard today was inconsistent testimony about where Carlos even was. Was she inside? Was she outside? We've already got a rogue fact that doesn't completely make sense on how she could hear something when she wasn't where it was being said. Maybe she heard it through a door. Maybe she did. If you start finding yourself maybes, ladies and gentlemen, you can move right to your verdict. She did not guilty. There's no room for maybes on this. I would say to you, ladies and gentlemen of the jury, it is not reasonable to state somebody was able to pull one little detail out of two people. And we did hear Carlos testify that she heard both of them screaming and yelling at the beginning of this. She was up in her room. She heard mama and dad yelling. She did testify that today. But the only thing she could remember was, I'll light your ass, which seems to be the only thing we've heard consistently from Mrs. Fisher the 3 times she told that story at me. So let's kind of back through that, because painfully we all had to listen to the 911 call multiple times to refresh everybody's memory, to make sure that we weren't misrepresenting facts to you, so you had the truth and had all the evidence to make your decision today. What we know is Mr. Fisher is on trial for one is handbag and allegedly acting like he was going to hit his wife. We know that that's the crime that he's on trial for. There's been no charges about aggravated assault or attempted murder or anything to do with a gun. But what we know is for the 10-minute phone call to 911, there are allegations about name calling, about parking spaces, about people being rude, but we never once heard Mrs. Fisher make the allegation that he put her in reasonable apprehension of being struck or harmed. She never said it. And thanks to you, you can use your common sense. Why? Why, if that was the primary act that we find ourselves here in trial for today, why wasn't it important enough to mention? Now let's just jump past that. So Mrs. Fisher is told by 911, if you're in fear for your life, you need to leave the home. She admitted today she had every opportunity to leave the home, but that's not what it was about. Instead, she fired back with, why do I have to? Why me? Why, if he's the one who's being mean to me and being rotten, can't you make him go? Now, I'm paraphrasing slightly what was stated, but again, to sit here and not have you folks all listen to 4 hours of audio on cam, that's what we did. We cut and snipped and pulled these parts together into the important parts that we need. Ladies and gentlemen of the jury, 2 officers show up. Mrs. Fisher's on the phone with 911, hasn't left, hasn't sought safety. She's in her garage. Mr. Fisher's upstairs, like Alice is back in bed. You heard officers testify in his bathrobe, and you saw yourselves kind of making his way back down from upstairs. What we know is Mrs. Fisher now has got her second opportunity to tell police what had happened. They show up. She starts with, "Let me tell you what's going on." She again walks through a very, very similar story that she told the 911 operator. Right? We were bickering about the parking. Call me pretty unfortunate names. She even then told those officers new information she had told 911 about her motive, actually. I don't think she was thinking that she was telling the officers her motive to be maybe a little exaggerating or maybe even just untruthful about what happened, but she did. She went on to volunteer information, very private, personal information about them, about their relationship, about alleged infidelities, about her wish to be out of a loveless marriage and move out, but it was a financial construct that was the only reason she couldn't. She's just listening for somebody who's listening, but as she's doing that, ladies and gentlemen, jury, she's laying out the motive as to why you cannot, here and now, take that statement as beyond reasonable doubt when it comes to evidence in a criminal case. We talked at the beginning of this today about the moms and dads of the panel. Hey, he's telling somebody's not answering. I don't think anybody today was staring down or looking away. But I would pose that when the questions became ones that the individual, Mrs. Fisher, didn't really want to answer, she didn't really answer. We had to go through the rigmarole, pulling up statements where she could remember what was said before, what was said after, but couldn't remember that specific statement until we more or less had to pull it out. And then and only then did she concede, okay, well, maybe that's what happened. And I'm not blaming her, I'm not here to do that, but just here for you to understand that there's a completely plausible another story. And if there's a plausible second story, you must return a verdict of not guilty. It's simply put right then and there that it's not beyond a reasonable doubt. Now, I'm not going to keep drilling on, and honestly, she gets a chance to stand up one more time than I do. I would love to be able to get back up one more time and we keep doing this all day long, but because they have the prosecution, such a serious high burden to me, she'll get one opportunity to get up and respond to what I'm telling you now. So I'm only going to leave you with a few more. Now, we know that 3 stories about what happened that night were told. 911, she ignores the advice to leave the home, makes no mention of this alleged handcocking and fake punch. We know that she's speaking to 2 officers. She's giving a detailed version of everything that had happened. We know that she makes no mention of it. We also heard Corporal Paisley, and I'm not saying that he was doing anything wrong, but we heard in a minute, he pretty well led her through filling out that form, the victim statement that you all saw. In fact, he regurgitated her story right back to her in a much more summarized version to kind of make it flow. And it was only then, that was the one and only time, if you go through the evidence today, that allegation about my client pulling his hand back to hit her, that was raised. I need you to think about that, and I need you to think about that part really hard. Reasonable. Credible. Did this person have motivation to maybe fabricate or at least bend this in a light that looked favorable? And we don't blame her. We can even maybe understand how she got there. It doesn't change the simple fact that this man's freedom was on the line, and it's on the line on some statements that can't really be corroborated anyway. The closest we have in corroboration was the party's daughter coming forward and stating that she heard Elijah. What we know is quite possible she wasn't even in a spot. I'm blaming her, just know that we have testimony that says inside, outside, and it's going to be impossible to hear things in the manner that she testifies. There's a lot of questions that can't be answered. And it's not for any of us to speculate as to why the couple or the family has handled things the way that they have, but what we do have in front of us today, ladies and gentlemen, is a lack of evidence. There simply is not been enough put forward by the people to meet this very high burden of beyond a reasonable doubt. Now, quickly, I do want to remind you back that when Mrs. Fisher actually very, very first spoke with 911, and the operator asked her, has he done anything to hurt you? And she parroted back, do you mean hit me? And then I will clarify, the operator, he clarified. He said, well, hit you or do anything to you. Ladies and gentlemen, if that question didn't beg the response of, he pulled back and acted like he was going to hit me, send help. I don't know what would. 911 was even ferreting out these answers, was asking the right questions, and it still wasn't the case. Now, the prosecutor raised the point about why do victims stay in dangerous situations. Ladies and gentlemen, what I'm telling you today, what the evidence is telling you, forget what I tell you. We're not talking about why would somebody stay in a quote dangerous or an abusive relationship. That's not even what the question is. The question is simply, if someone testifies to you under oath and tells you, I genuinely thought this person shoot you. Use your common sense, ladies and gentlemen. Sticks around. Who has the answer of, I'm not going anywhere, it's my house? The person who's not truly in fear for their life. That's who. So as you're, again, doing your deliberation and talking about what you heard today, ladies and gentlemen, I think it's very important that we do focus on that. We know that there was a new issue that had been raised at the very end about Mr. Fisher being taken away a vehicle. I think this is the first any of us had ever heard of that today. Wasn't any police reports. First time it was brand new information. One more basis and motive of a really angry individual who was not access to divorce courts to resolve their differences with their husband, but instead used the criminal system to have Mr. Fisher removed from the home and less than ceremonious into the relationship. Ladies and gentlemen, heard the officer's testimony about Mr. Fisher's cooperation in his general mental state. You saw with your own eyes what he looked like as he walked down the stairs. I would ask you again, use your common sense and think about what a reasonable person within apprehension this individual is going to be, striking them, hitting them. You remember, Mrs. Fisher reluctantly, when she was being cross-examined today, and I'm sorry I have to do my job that way sometimes and interrupt and say that's not the question, but that's how this works. That's how we have to get to the truth. And when pressed on this today, what went from I was the only one catching insults to finally it was, well, okay, well, maybe I did say I was going to knock his head off too. So even as she was pushed today, she slowly started to get a little bit of ground. Now remember, ladies and gentlemen, you got a great looking sweater. Be a little string sticking off with it's no consequence. But when you start pulling on that string, you do start seeing the holes in that sweater. And I thank you for your time today to allow me to start pulling on that string to show you there's more here that we don't know. With that being said, ladies and gentlemen, thank you for your time. And I ask that after hearing all of the evidence that's been presented to you today, of judging the credibility of the witnesses that you heard it from today, that you return the only right and just verdict, which is not guilty. Thank you.
Ms. Mandernack.
Thank you. I'm just going to briefly address points that defense counsel brought up. So defense counsel emphasized that Miss Stacy Fisher did not tell the 911 operator that defendant had held his fist back as if he was going to hit her. Again, I submit to you that the reason that she did not immediately state that to the 911 operator or to the police when they originally responded was because she was more concerned about the firearm use. That is the bigger threat of the play. She did tell Corporal Paisley when she was giving her written statement that defendant pulled his hand back like he was going to hit her. But again, she was more focused on the threat to shoot her because, as she stated, she can probably, or as Stacy Fisher testified, she can probably survive being hit by a defendant, but she can't survive being shot by a defendant. I think that's very important context when taking into account when taking into account when she disclosed the part about him pulling his fist back. Regarding Carlos Fisher's testimony, she testified that she was in the garage, walking back in, she said that she testified that she overheard her parents arguing. She overheard both of them arguing, or both of them yelling. And then she testified, I believe, she was standing behind the garage door when she overheard defendant say that he was going to, when she overheard defendant yell that he was going to lay her arrest in reference to her mother, Stacey Fish. As I previously stated, I believe that when you look at the totality of the evidence, the totality of Stacey Fisher's testimony, the fact that portions of it are corroborated by Carlos Fisher, it's corroborated by a written statement, it's corroborated by the body cam that you heard and saw, I believe that you will return a fair and just.
Thank you both. All right, folks, home stretch, final instructions. If you want to follow along, that's what they're under, final instructions in the submenu. Starting with page 1, duties of judge and jury. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors, who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied, beyond a reasonable doubt, that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide the case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it's your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. Moving into elements of the crime. The defendant is charged with domestic violence. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant assaulted Stacy Fisher. A battery is the forceful, violent, or offensive touching of a person or something closely connected with him or her. The touching must have been intended by the defendant, that is not accidental, and it must have been against Stacy Fisher's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend immediate battery. The defendant must have intended either to commit a battery or to make Stacy Fisher reasonably fear an immediate battery. An assault cannot happen by accident. At the time of an assault, the defendant must have had the ability to commit a battery, or must have appeared to have the ability, or must have thought he had the ability. Second, that at the time, Stacy Fisher was the defendant's spouse. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about October 22, 2024 at 6112 Swan Lake Road in Romulus within Wayne County. When you go to the jury room, you will be provided with a written copy of the final jury instructions. A copy of electronically recorded instructions will also be provided to you. First, choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual, considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to Officer Krova. It is not proper for you to talk directly with the judge, lawyers, or other people involved in the case. If you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all of the reference documents or exhibits that have been omitted, just ask for them. When you go to the jury room, you will be given an electronic copy of your instructions you have just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. Joe will give you a jury verdict form as you walk in. I'm moving on now under submenu to evidence instructions. If you believe that a witness previously made a statement inconsistent with their testimony at this trial, the only purpose for that which the earlier statement can be considered by you is in deciding whether the witness testified truthfully in court. The earlier statement is not evidence that what the witness said earlier is true. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. She only has to show that the defendant actually committed the crime and that he meant to do so. Back to submenu, witness instructions. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. Counselors, are you satisfied with the instructions as given?
Yes, Your Honor.
Yes, Your Honor.
All right, folks, this is absolutely my least favorite part of the jury. There's 7 of you. Now, after you've all been so engaged and attentive, I'm going to kick one of you off. So you all know your number. So I've got 7 little beads in this can that are numbered. Juror number 4. Thank you for your service. Now, I will say this. When we're done, after we've got the final verdict and we share that with the courtroom, I'm going to go back and do what I call a debrief of the jury. I'd love it if you want to stick around. You can go back in there and get in on that final conversation. So I have a chance to answer any questions anybody has, a process and all that stuff. All right, but don't feel that you have to. I just want to make the invitation. Thank you, Mr. Tomlinson. All right, so with that, Joe can take the jury back in to deliberate, and we are in recess. Do you have anything in the back room you need to pick up?
In the end, the law demands certainty, not suspicion. If doubt remains, the only verdict that honors justice is not guilty,